Welcome to another episode of Lawyer v. Lawyer. Hello, Debbie. How are you?
Hi, Gary. Long time no see.
Yeah, and so we're recording this on Zoom. We're still in the COVID and Corona lockdown, and numbers are going up. How is your practice and business going through this, Debbie?
So what's been interesting, Gary, is I don't know if I told you this or not before, but when we first started this in March, my associates came to me right before the firm shut down for weeks and weeks, maybe months, and said, we want to stay here and work. And so I said, fine, if you want to stay here and work, we'll stay here and work, but we have to be in each other's bubble and you can't go out running around doing this, that, and the other. So we did that. And as a result, it has been very successful because for once in my life, clients can actually find me. I'm not in court, I'm not in depots, or at least I wasn't during that period of time.
Right.
And so we have been pretty lucky. When we opened back up, there was a scenario where one of our attorneys went to a outstate court with a mask on. It was one of the first personal appearances after that first round of COVID when we were all closed and the courts had started opening back up, particularly outstate. And he went there, and a judge did not like when people were arguing with masks on. It made it hard to hear. He took the mask off to make his argument and received a call the next day, fortunately before he'd come back to the office, saying that that somebody in the courtroom, one of the attorneys who had to take his mask off, had COVID. And so my associate partner got COVID as a result of that. So that was our first COVID experience. He did not come into the office, so we were lucky on that. He stayed home.
So is this episode about judicial immunity?
Isn't that funny?
Do you need me to represent him in the work comp claim?
No, he had no bad effects, none whatsoever. But actually, we have had, I think, just a small firm like ours, we've had about maybe 4 people who have been diagnosed with COVID. And fortunately, while one of them might just be a little bit sick or flu-y for a week, and another might have 4 weeks of some symptoms, nobody's been seriously ill and within the firm. And we've just been really, really, really lucky. We had our first exposure last week in the firm, and that we all came out just fine on too, because everybody got tested and we were good. Firm.
Well, that's good. That's good. Yeah, we've gone down. We've done different things in our firm. We were closed and we're working remotely, and now we're back to the office. We were back to the office 2 days and then 3 days a week, trying to balance productivity with isolation. And then the numbers went up. So we're back down to 2 days a week. And after this, we're recording this after Thanksgiving. I said, listen, the numbers are going through the roof. Everybody stay home the week after Thanksgiving.
That's what we did too.
Yeah.
Yeah. Just because we heard, all the college kids are coming home. People want to be with their families.
They do. Yeah. Yeah. And that's what I tell my kids and my staff, or my staff who are my kids. This thing is always changing. So, we need to change with it and stuff. And so, like my one daughter will be like, but you let me do this. I said, yeah, that was in August. Now, I don't think we can do that anymore. So, listen, let's turn. Look, So speaking of this, so speaking of the current time that we're in, one of the things that is just all over the news from the lawyer's perspective is the multiple motions, pleadings, arguments made across the nation regarding voter fraud. And I don't really want to get into the politics of it, Debbie, because that's not productive. Maybe it's a divisive time in America. However, this has brought home ideas about evidence and basic evidence and documents and witnesses. Have you, and I know you're voracious news reader. Have you tipped to the same ideas or the same lessons?
I wish I was a voracious news reader. I am not. After 9/11, I stopped watching all the news, but you can't avoid this news. You can't avoid it as much as I might try. And I have noticed what's going on. And I've also noticed kind of a parallel trend in the cases that I have right now in following the same sort of, is the word rhetoric, of what's going on in the national news compared to what's going on now in cases where you will get allegations and arguments completely unsupported by any substantial evidence. And so that I've really noticed. That I've noticed a lot. And the second prong of what I've noticed that causes me a little bit of pause is that, Gary, you know that if in this city, this county, if an attorney who lost a motion or lost a case made comments about the court or the judge regarding the judge's ruling on that case, rather than just, we disagree with it, we don't think the jury did what was right, that's fine, but, and we're going to appeal, you might hear those things, but you don't hear the types of attacks on the judiciary, and the comments about the judiciary. You don't hear that from parties or lawyers against the judiciary, and that is a trend that I'm not liking at all that I'm seeing.
So you're saying, well, let's parse this out. Let's take that first. So you're seeing comments against the courts, against the judicial decisions?
Yeah, against decisions for rulings, dismissals, rulings on evidence, rulings on motions to dismiss where a cause of action was claimed but didn't sustain either the burden of proof on a motion for summary judgment, or didn't allege properly a cause of action that is cognizable under the law. And then you will see parties or candidates or supporters of parties or candidates or attorneys go on and talk about the impropriety or the bias of a judge who rules on a motion.
Does that rise to the level of being an ethics violation in your view?
Well, I think it depends on who you're talking to and which case you're talking to. But I had a friend on Facebook who I got a big kick out of this because, we're all goofy on Facebook. And I had a friend on Facebook who said, I think it is time for a sua sponte ruling on sua sponte finding regarding a Rule 11 violation. And so you get that. I get that. People who aren't lawyers don't know what that means. So people were writing things like, "Ooh, when you talk Latin, it really is sexy," stuff like that. That's what they were writing. But the
right.
being,
this, I don't think. Yeah, no, I hear you. You got to. You're right. The problem with what this criticizing the judiciary and criticizing stuff that we see in the political world is those politicians are trying to get an immediate short-term game. They're not thinking about the long haul. What about the next time you're in front of that same judge? You and I have careers spanning decades, and the next time you're in front of that judge is thinking, listen, I'm not going to listen to you. The last time you did this, that, or the other thing. You really, as a lawyer, if you engage in that conduct, you lose your credibility and your respect towards the tribunal and candor towards the tribunal.
Absolutely.
I would never say anything. I would never say anything behind a judge's back that I wouldn't stand up in court with my duty as a lawyer and say to their face. If I disagree with them, I disagree with them. I'm going to tell them why and try to do it cogently. Which is nothing wrong with that, but this backstabbing, you kind of slink out of the courtroom, and then what are you going to go slam? Well, you have the guts to say it in the courtroom.
Well, and you know what, Gary? That is why people don't like lawyers. That is what hurts our profession. If you have an attorney out talking to the press and talking to the public and denigrating the person who is in charge of calling strikes and balls, talking bad about the referees, people believe that. People will believe anything you tell them sometimes. And so people then turn around and repeat it, even though it had no evidentiary support, even though it was completely just sour grapes. And it makes us all look like it's a backbiting and bad profession. And it makes it look like the judge, if somebody comes out and says, oh, well, this judge was biased against me because of A and B and C, completely inappropriate in my opinion. And that's really frustrating to me.
Yeah, and
I mean, to be frank, I'm probably worse than you are. I might say something behind somebody's back and I might call you and say, what the heck is going on with this guy? This guy hates me. This judge is terrible. I don't, da, da, da. But I'm never saying that in public. I am never, that is not coming out of my mouth. I don't care what happens in trial. There, it's not a public issue. The question is, did the judge get it wrong or right for the Court of Appeals to decide, not me? Because I know I don't have, if it's my case, I don't have an objective view.
Right. And well, I don't think I've never heard you talk bad behind someone's back, but we do talk to each other about, hey, what's this judge like? What's he going to rule like? You want to know when you're going into there. What's this lawyer like? You know, and there are, so we do talk about that because you're like, am I the only one? And they're like, no. The judge is, she's like this to everybody. Or this opposing counsel, is it me? No, I literally had a conversation 2 days ago. And the other lawyer already knew this lawyer. I didn't bring it up, and he brought this lawyer up, and we both had the exact same experience with this lawyer, years apart, separate litigation, and we both had the same view, and that's reaffirming. So that's different. So there are specific ethics rules about you can't go to the press or make public statements about a trial or an outcome before it's over. And there's specific ethics rules about this. Right. And is at one point I'm
never going to remember.
And I'm very careful about that. I don't, and you've had high profile cases, you know, because I don't want to jeopardize the result. When people do that, it's about the lawyer's own ego. It's not about the client's interest, I think.
I agree. So, right, I'm glad you brought that up. I mean, we haven't really been talking about evidence, but
let me turn to that. Let me. Yeah. So here's the thing that's shocked me is the large number of lawsuits and complaints filed with allegations that all these cases are getting dismissed because they don't hold any water. There's no evidence to support these allegations. So there's all of them are dismissed. I mean, and there's not a shred of evidence. And we as lawyers, before I could make a claim or you can make a claim or I can assert a defense or you can assert a defense, we have federal rule 11 or whatever rule. You have to have a good faith basis in order to make that claim. You have to have a witness who says it. You got to have a document that says it. And this hearsay on hearsay, there was a lawyer, one of the president's lawyers is actually from St. Louis, and there was this argument between him and the judge where the judge was saying, "Isn't that hearsay?" He's like, "No, it's not hearsay. I'm saying that someone else said something, and then someone else something. Isn't that hearsay?" So there's evidentiary rules that we have, basic stuff you learn in first year of law school that is routinely being violated or ignored. So let's talk about evidence. So I guess I've been talking for a minute. Let me just get your thoughts on that, Debbie.
I think you're exactly right. And that's one of the things that I see in the short term dripping down to what we do for a living. And I've seen this, you do see this a lot in like employment cases where there's a lot of hearsay. The person comes in, they talk to you about the employment case, one side or the other. And there's a lot of stuff. Well, this guy will say this and this guy will say this. And of course, that guy doesn't say that. And so you may have good faith reason to believe he's going to say it. You can't talk to him because maybe from your side, it's still a managerial employee and your client has given you a good faith reason to believe the guy's going to say that. And then down the road a while, you may find out you don't have the evidence. But to the extent that you can get the evidence beforehand, man, oh man, that's what we're supposed to do. And I don't see it happening. And I see case after case. I've got a case right now. This is goofy. It's just goofy where my client who had absolutely nothing to do with the contract at issue was and didn't provide benefits under a contract to this person who is suing them. I don't want to give too much detail. Has been sued with other people who refused to be part of the deal for civil conspiracy to breach a contract. Goofy. It's the goofiest thing. Guess what? There's none of. There's no evidence that any of these defendants have ever talked. There's no evidence that any of these defendants know people that are in the other groups. There's no evidence at all. None. And so, 20 years ago, this case, there's no way it would have been filed. It wouldn't have been filed. It just wouldn't have. It just wouldn't have been filed. And so now people believe if I say it, that's enough to allow me to move forward. Or if I say it, that's enough to defend me in the case. Now, one thing I'll point out, Gary, and then I want to hear your thoughts on this evidence thing, and that is this. I'm also hearing from people who believe that idea that they get to say things and that is sufficient to allow the case to either move forward or the defense to be able to thwart the plaintiff's case. I'm also hearing just the opposite when it comes to whatever the other side's evidence is. So you'll have somebody who testifies. Now let's just, for argument's example, say it's a plaintiff, and that the plaintiff says, I did not have injury before in this area. I had no problems or complaints, never had any medical treatment. But after this, here's what started happening with me. And I continue to have this sort of practice. Well, where's your evidence? That was it. That was my evidence. Testimony is evidence. And so people are, I mean, it's
Isn't
good.
that crazy? So,
No,
I'll tell you,
all the time.
I never thought that the fake news phenomena in the last 4 years and I don't want to, what you just said is the same thing when the president tweeted, Joe Biden has to prove he got 80 million votes. No, he got 80 million votes. Those are all certified election. He doesn't have to go do that. It's the same analogy. So, but I honestly, right. I never thought that this stuff would bleed into the legal practice.
No, I didn't either. That's been the big surprise to me.
See, you know what I've seen?
We've seen so far, Gary, when we're not really practicing, we're not even really in court doing a whole lot. And
that's what I've had a couple disputes with lawyers where they're saying all this stuff to me, this and this, and accusing me of this and all this stuff. And I'm like, and I'm thinking, why are you saying all this? You're not going to say this to the court, because you're wrong. I mean, but I don't want to get into I don't want to be a 5-year-old saying to them in an email battle. I just kind of leave it and let it go. And yeah. But I'm like, you're saying all this stuff very aggressively. You're a powerful email writer, but are you gonna go and say that to the court? And then they don't. And they're boy who cried wolf type of thing. So
doing, Gary, it's preventing us from properly being able to evaluate cases.
Well, here, let me ask you. Yes. Well, hold on. Yeah, I'm sorry. I didn't mean to cut you off, but I had another.
No, that's question. All I had to say.
Well, here's the question. A question is, but what ultimately all you can do with that is cross-examine a witness at trial. So the question, when we start trying cases again, and someone comes up and makes a bogus allegation, doesn't have a whit of paper, or you can cross-examine it, you think juries are going to still think you think it's going to work? You think this is going to work in front of a jury? I hope not.
I'm worried about it.
But it makes me think maybe it will. Well, you know what? That lady said it. Yeah, but she had 7 other documents where she had a prior inconsistent statement.
Right. I think I'm worried about it because I do think jurors look at both sides and think, okay, you proved to me this, and now you proved to me this, when only one of them has the burden of proof on the issue. And I think people are now accustomed to believing what they read because we've so diversified on where we get our news. And so they trust whoever their news source is and they believe whatever the news is. I guess I'm a cynic, and I don't think I'm a negative cynic, but I think it's hard for me to believe anything I read without, I have to analyze it myself. I want to decide whether that's true or false. I don't think that's
don't you think with spurious allegations in a complaint or some of these other examples, don't you think those lawyers and clients open themselves up to Rule 11 sanctions or malicious prosecution claims? Or, I mean, I'm not saying you would make them. I'm not a sanction guy, but I mean, if you have a client, use your example. If you have a client who spends a bunch of money defending this lawsuit and if there's no merit to it, um, isn't there an abusive process or some type of a consequence to that?
You know, there are those claims, but you don't see them often enough. I mean, you don't see them often enough. And on one hand, I've never filed a Rule 11 sanction motion, but that's the problem. Part of that reluctance is what has allowed people to make claims they know they can't support, and then they try to win whatever they're trying to win in the court of public opinion, or the jury of public opinion, when it's
Mhm.
just opinion and not evidence. And so that, I don't know. I mean, you know, we're so reluctant to do it. It's not just you and me. We're all reluctant to do it. You just don't see a lot of that. And when you do, those are the people who are hated in the law. These people who always try to get sanctions. And
Well, it used to be that the people who always filed sanctions were the ones that were full of malarkey.
right.
Now, but I wonder if it'll switch in the next 5 years to the bogus pleaders or the people put forth bogus claims then need to be marshaled in by our some of the mechanisms we have under our rules to prevent fake news from being put into evidence in court.
Yeah, I wonder, it will start in the federal court if it's going to happen, I would think.
Isn't it interesting, though, that we have a huge body of law about to guarantee the veracity of evidence, about you can't have hearsay. To put a
Right.
document into evidence, it has to be authentic. You have to have foundation. All these rules that you learn, which tells me that all this malarkey went on years and years ago, hundreds of years ago, because there's a reason why we have all this law
Oh,
for people to stop people from putting fake evidence into court.
that's an excellent point. Well, that's an excellent point.
I finally got to. It's been many episodes since you've said
No,
that. So,
no, I really think it's an excellent point. It just kind of turned a light bulb on. You know, I remember, gosh, I think it was during the Bush Gore fights when we had a lot of these same sort of issues going on that are going on right now. I remember getting and reading a book on, it was probably Ron Chernow or somebody, a book on George Washington, and hearing and reading about the political fights that went on back then. And I thought, what? This stuff happened before? You know, you think whatever you're going through is the first time. So I think you probably just identified the exact reason for those rules of evidence. That's
they
exactly.
played dirty then. They would print these pamphlets with completely bogus claims and yellow journalism and all these newspapers. I was reading a historical article about libel and slander, and how they would also use lawsuits to try to shut down papers when they were doing proper news, but there was also fake news. There was actually a case out of the first case that gave public officials that lesser standard. You can say whatever you want about public officials. You can't sue because they have a separate status under libel slander law.
Right.
It was a Michigan or Minnesota Supreme Court. The opinion that was reversed by the U.S. Supreme Court said, well, you know what? It was a bogus newspaper. That was a terrible newspaper. So we're gonna let the suit go forward. So this brings us back to the point that we started with, Debbie, in this podcast. So let's just talk a little bit about the basic evidence rules that we're talking about. So let me just go. So whether you're trying a case to a jury or you're going to a judge in a TRO or a motion hearing where you're putting on evidence, you never say anything in an opening statement that you're not going to put evidence on and prove, ever. And when I get ready to try a case, I sit there and say, how am I going to prove my evidence? What is my logical trail? How do I get every document in? Is it authentic? Do I have a business record exception? Is it going to get around hearsay? Is it going to come in? With the witness, what are the motions limiting? How is this witness going to say that the other car was speeding? Did they see the car? You need to say that. What's their basis? You need to create a foundation for that, right? So you need to, so we have basic rules about authenticity of documents, that documents don't contain hearsay within hearsay, that you only put proper documents in front of the jury. We also have which not to dovetail, but that's one of the reasons why you don't have all this pretrial publicity, because there's a difference between what you can say in front of a TV camera versus what you can really prove. And then I'm going to let you talk. I know I'm talking for a minute, but
you're not. You keep telling. I've been talking a lot.
Well, no. Then on witness testimony, the same thing. If you're going to put a witness on, don't have them say something that a document's going to counteract, because it is going to be your first exhibit, Debbie, and then all their testimony is thrown out the window because the jury won't believe it. So the jury has to have firsthand personal knowledge about what they're talking about. They can't guess or speculate. They're a lay witness. They're not an expert witness. They can't say opinion. They can't say hearsay except for certain reasons, et cetera, et cetera, et cetera. So we have a very regimented way of placing accurate information in front of a court that seems to me to have been ignored in the last two or 3 weeks or however long with this flurry of these cases. So anyway, there's my little speech on evidence.
Well, in what has happened, what we see is opening statements, which are supposed to lay out factual evidence for the jury, and maybe in an argumentative way, although we're not supposed to do that, but we do. But what we have instead is we have an unsupported closing argument about the facts of the case, which again are unsupported. And so it's like somebody gets up in an auto accident, and instead of talking about how the accident occurred and what the injuries to their client was, they say, this guy that day, he had 3 kids at home. They were loud. They were running around. They had to stay home because they were going to do and he was trying to get out of there. They were going to be doing virtual teaching. He was trying to get out of there. So he was in a hurry and driving recklessly. And then, you get that guy on the stand. You have children at home? No. So you don't have children? No. And so that day, were you in the hurry to get to work? You were running like, no, I was an hour and a half early. That sort of thing. And then it diffuses it, but you've already gotten the jury mad, and you already have all these people believing something that's not true, and it's hard to change their opinion. You can do it, but when you're talking about a court of law, you can do it because they are instructed to follow the evidence. But in life, when they hear it on the news, it's hard to change people from unsupported, irrational beliefs. So,
and that's why it's done, is that
right.
The petition that's filed or the motion that's filed, that's going to get the headline 5 days later or 2 weeks later when it's dismissed by the court because there's no evidence to support it, or it's hearsay, or there is no affidavit, or you actually talk to the witness and they say, oh, I know in the affidavit I said I saw this, but I didn't see it. I heard from someone else who saw it, blah, 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 which has happened.
Right.
You don't hear that. You don't hear that. You heard the headline in the first instance, and you don't hear the vetting of the information.
So one thing we've all learned, this, all lawyers know this because they have been involved in lawsuits, but normal people don't know this. And that is, when an event happens, particularly a catastrophic event, people who were in the proximity of that event put themselves in the middle of it when they really weren't. And I remember years ago in my hometown, there was a school shooting, and kid comes in, and so now you've got 200-300 people. No, you probably got 400 or 500 people in this high school, and they all now know something about the people who were killed, about the kid who did it, about the history, about what happened there before and after, when really only about 10 people had any personal knowledge of it at all. And so those other kids start talking about what happens. That becomes fact to them, because they they're emotionally and mentally working through the facts that they understand to be the facts. And then news gets out about what might or might not have happened. And it was interesting to watch that, to me as a lawyer. It was devastating to watch, but it was also very interesting to see these kids who had nothing to do with any of this put themselves in the middle of the event as a witness. And they would say things like, well, I had talked to him the day before and he said this. And then the cops would say, well, did you try to stop him? Did you do that? You know what I mean? It would lead the police officer down the wrong road. And it was really kind of an exaggeration of some little piece of fact because they wanted to try to be helpful. They wanted to try to solve the problem. And they wanted to second guess whether they should have made a different choice when approached by or in the presence of the shooter or the witnesses. And it was it was fascinating as to how that worked out. And sometimes what happens is we have as witnesses some of those people who aren't in the middle of it. They don't know. And that's who you base your claim or your defense on. And then later when the evidence comes in, you realize, oh, this person thought they knew what they didn't actually know. And I remember telling my niece and nephew, look, you were not, they were there, they're there at the high school. You don't know why he did this. You don't know what happened. You weren't there. Shut up. Shut up. Just keep your mouth shut about things because you had nothing. This is not about you. This didn't have anything to do with you. And at some point, there was discussion even of one of the children who attempted to stop the shooter being a conspirator, which wasn't true and didn't happen. But at some point, there was a discussion about that because he was so intertwined with what happened. You exaggerate your own role in it. And that's what happens in lawsuits all the time.
All the time, all the time. And people don't want to acknowledge that. Like all these people are saying this stuff in our Facebook and our society or whatever, but they don't know that it's true. And people don't want to acknowledge this part of human nature where we are liars. People are liars. They say everybody lies 10 times a day. And now they could be white lies. People want to have a self of self-importance. They want to be able to be better storytellers.
Right.
The people who say in your example, the people who say they saw the shooter or this or that, or the people who say they heard this witness say this guy was drunk or whatever the other, in a car wreck or whatever.
Right.
They're not, it's not necessarily malicious or evil or whatever, but they're lying. And or exaggerating or whatever, and it's just part of human nature to do that, and we get that all the time. I have this all the time in these cases. Well, they tell me all this stuff about the case. Then you say, well, how do you know that? Because and this is just like all these cases that are being filed on this election and trying to throw out this election is, well, you saw someone, you say you saw someone submit a false vote. Did you see him? Who was it? Who was the voter? Was that vote counted? Let's connect the dots. And then you find holes in it. And we as lawyers, we see this all the time as, I didn't see, how did you know the light was red? Well, how'd you know the light was red? Well, did you see the light? No, you were on the other, you're nodding, Debbie. You've right. Cross-examined witnesses like this. No, I was on the other street. Well, other cars were stopping. Well, how do you know why? I mean, what do you know? Maybe it was a yellow light. What was it? And then I literally did a depot prep yesterday where they're talking about stuff. Well, this defendant driver was mad and acted like this. Well, how do you know that? Well, my friend's grandfather was there and saw it. Well, that's like quadruple hearsay, blah, blah, blah. So, you got to examine these sources of information, and lawyers and the media is trained to do that. Good media sources don't just publish stuff because they're going to get sued under these libel slander laws. So they got to check their sources. They got to ask these basic questions. People and this line and this sensationalizing, want to be part of the story. It both happens with the storytellers, and then everybody on Facebook wants to say they were part of this and they know all this is true. You don't know that's true. You're spreading something you read.
Right, right. You know what? I have a friend who always says, I haven't met a story I couldn't make better.
And you know, and the joke is you talked about employment cases, you know, the old joke in employment cases, and it can be true in other cases, is after you do your initial interview with the plaintiff and they leave your office, relish that moment, because that's the best your case is ever going to be.
That's exactly right. That is exactly right.
So it's just something to be mindful of, the parts about human nature, and it's not good or bad. We are who we are, but we got to guard against it. Everybody getting all in a huff and a tizzy and think stuff proof. There's a difference between evidence and accuracy. Don't you have a lot of, Debbie? Don't you have a lot, now that we're kind of honed in on the subject? Although evidence rules are a pain in the rear, aren't you glad we have them?
Oh my gosh. Yes, I am. I mean, what would we do? Think about that. It would just be, I mean, okay, so I will say this is naive, but I truly believe 2 years into the practice, that most of the time, and I mean like 98% of the time, the case works out the way it should. Maybe not the way I wanted it to, but the way it should under what the law requires.
I concur.
It really does. And the reason for that is the rules of evidence. Because if we didn't have the rules of evidence, things wouldn't work out the way they're supposed to work out. And when I say supposed to work out, I don't mean for me. I don't mean, you know, I'm talking about for society under a rule of law that allows people to obtain compensation when they meet a burden of proof, which is put upon them to prove somebody else did something wrong, breached contracts, slandered them, you know, was negligent, whatever. And if we both play by rules that are the same rules, then everybody has equal opportunity for justice, one side or the other. And
that was really well said. That was.
I don't even know what I said, but
no, you say it's a rule of law, and that's great. And you know, and you know, when you said it, even not the way I want, you know, if I have cases where it doesn't go quite the way I want, after a while, after I cool off and I digest it and I can step back, I go, you know what? That was probably right. Or, you know what? I don't want to admit it, but you know what? I think they were probably, you know what? That other lawyer was right. I may not have liked the way they said it. I may have been trying to win this point, but you know what? There you go. So
yeah, I do too. I can't tell you the number of times when I get an order or something, I go, what were they thinking? And then 3 days later, I go, "Oh, that's what they were thinking."
or the when you're done with the trial, and you get a result, and then 3 days later, you're like, you know, I know the judge ruled against me on this stuff, but thank God she did, because otherwise I would have so much error in this case. Thank God they didn't let me do this.
Every trial, and you try really hard not to put the judge in that position, but you do. You do, and you try not to, but you are so right. You are so right.
All right. Well, we've been going about our allotted time, Debbie. I really appreciate. I really have a lot of good season of gratitude. I have a lot of gratitude for you in this podcast, and this has been a great conversation about how our current how the stuff we see in the news about fake news and these court cases kind of applies to the law. So thank you.
It's good to get back together.
All right. All right. Thanks for everybody for Lawyer Be Lawyer. You can get other episodes of this podcast, listen to us. That's all I have. Thanks, Debbie.
Thank you, Gary.